right. Hi, everyone. My name is Sarah Coffey. I am the Victim Services Manager for New Mexico Legal Aid. And today we're going to talk about divorce and custody cases when there is domestic abuse going on. I'm a very informal person. If you have a question and I don't see you raise your virtual hand or see you waving at me, just interrupt me. Feel free. I don't mind. I think that the goal is for you guys to get the most out of this and for you guys to really learn what we're talking about. So if you have questions, if you want to talk about things, please, let's do it. So I'm sure you guys are all very excited because I have a PowerPoint and no one has seen PowerPoints in the last 2 years on Zoom. So we're going to do that. And let's see here. Let's get moving. Okay. So, okay, so like I said, we are going to talk about divorce and custody cases in domestic violence. And I want to start out by kind of flagging that New Mexico Legal Aid does have a domestic violence, sexual assault, and stalking legal helpline. The phone number for that helpline is at the bottom of the screen. This number is answered Monday through Friday, 9 to 5. So when we're talking about this and we start talking about like how to give information versus what's legal advice, when you get into that legal advice category, use this domestic violence helpline, and that way we can maybe help your clients if we need that. So phone numbers down there, please feel free to use it. And okay, so the first thing that I want to talk about is, I guess, unexpected, because the first question that you guys should talk to your clients about is what they want. Honestly, I tell people not to file for divorce or custody probably close to as often as I tell people to file and then how to file. And there are a lot of reasons that filing might not be the best answer. And I will tell you that in my experience, the courts disagree with me on this. The courts always want you to file. So if you're in an order of protection hearing, sometimes the court specifically tells the victim you need to file for divorce or you need to file for custody to deal with these long-term things. But filing for custody opens the door for a lot of stuff. So really thinking things through, because once a case is started, you can't stop it. So I also will say that private attorneys don't advise as much to not file. And there's reasons for that. There's, if you're not going to file, then you're not going to be their client, which means they're not going to get money from it. And there are benefits to filing. So a lot of times private attorneys play that up. But so let's talk about why you might not want to file. So I have examples of questions to really talk through with your client when she's trying to make this decision. He's trying to make this decision. Is the other parent bothering you? This is a really critical question. Because I definitely get phone calls on our domestic violence helpline where people are saying, okay, well, I had a domestic violence incident 5 years ago. I left and I cut all ties, and my child's about ready to start kindergarten and I want to file for custody. And it's like, okay, when was the last time you heard from the child's other parent? And if the answer is 5 years ago, okay, do you think that the child's other parent is going to randomly show up? No, doesn't even know where we are, doesn't have any interest, okay? What is the benefit of filing for you? Well, I just have the paperwork. Okay, I mean, that's definitely a benefit, and some people really need that stability. But thinking through of, okay, well, if you file for custody in this scenario that I've come up with, You file for custody and you have to serve the other person with that custody paperwork. And now when you've been off their radar for 5 years, been away from them, they're suddenly reminded of everything. And sometimes that re-engages them. And sometimes that brings an abuser back into a survivor's life. And they see an opportunity through the court system that they get to see the survivor. And maybe they're like, okay, well, no, I do actually want to see the child. Now there's an avenue for them to easily walk in and say they want to see the child instead of doing the work themselves and actually going forward and filing for custody themselves, finding the survivor and really doing that work. So these are the things, these are the reasons to think these things through. So is the other parent currently bothering the survivor? The answer is no, then filing might not be the right answer. Will filing make the other parent start bothering the survivor? I mean, that's the basic things. We're trying to create a situation of safety. And if we think that that's going to, be like, okay, whatever, fine, go ahead and file. If we think that that's opening the door to some kind of harassment for the survivor, then what are the other benefits? And is there a reason to file for divorce or custody? Will the other parent file themselves? Sometimes this is a good thing, and we'll talk about that later, but it's something to really consider, because if you're going to end up in the courts either way, that's, that helps that you're going to end up in the courts either way. I just want to get it moved. Because like I said, once the court process stops, it's not easy to stop, and there are then court orders that you have to follow. Will the other parent say they want to see the child but not actually make any effort? So this is one that I think is really important, because if your survivor files, they serve them, the court sets a hearing on something, that other parent just shows up and can say, I want to see the child. And they haven't done anything to address their abusive behavior. They haven't, but they have this way of showing up and just saying they want to see the child. And a lot of times, I can't say specifically, but a lot of times the court let them see that child at this point when they made no effort. Whereas if you don't file, they won't go through the effort of filing themselves to be able to see the child. And so now you have a situation where your survivor took action, took time out of their day to try to get a custody order. And that ended up being that now the abuser gets to see the child when previously you were kind of in your own little world and going along smoothly. So you don't want to open the door to something that wouldn't happen normally. Does the other parent know where the survivor is? This is a really important one, especially if they've moved from a different city, a different state, anything like that. Because, okay, if let's say there was an abusive relationship and that was happening in Las Cruces, New Mexico, and the survivor's like, you know what, I'm going to stay with my parents in Farmington. I'm not dealing with this anymore. And they go to Farmington. And then they get back on their feet and they're like, you know what? I've heard really great things about Silver City. I want to move to Silver City, but has no connections there. That abuser's not going to know where the survivor is. And when you file in the county you're in, and now the abuser knows where that survivor is, and that could open the door to a dangerous situation. So if they don't know where you are, really think through of, one, do you want that person to know where the survivor is? And two, will that create a dangerous situation? And these are really important things to just talk with them about. These are all discussion items. None of this is getting into whether yes, you should file or no, you shouldn't file, because that would be legal advice. But really talking to your client and making sure that they're thinking everything through and have a good picture of things. That is absolutely something that advocates can do. And then the last one is huge. Is the survivor mentally prepared for the court process? The court process sucks. Like, it just sucks. In no way does anyone say, you know what, I had a really good time in court. Like, that's just not something that people say. A lot of times they have to see their abuser, who they haven't physically seen a lot of. They have to listen to their abuser, and sometimes people really use the court system to say their piece, to undercut people, to say horrible things. They're subject to cross-examination from attorneys and ask horrific questions. And the questions are oftentimes legally acceptable questions. And you're stuck with what the judge orders. So if you get a judge that doesn't see things the way you think it should be seen, and they order that, your 6-month-old will have to go to your abuser's house who doesn't know how to change a diaper, you have to follow that court order. So making sure that they're mentally prepared for the process and what will come out of that is really important. And sometimes people want to do it. Other times people need a minute. And it's okay to need that minute and not take those actions immediately. And I think that that's one of the big supports for survivors that's missing, because, well, you're just supposed to file for divorce. You're just supposed to file for custody. That's not always the case. Every single domestic violence situation is unique. And every survivor has different needs and different ability to face what's going on. And so we have to be really cognizant of that and not have a checkbox and a one-size-fits-all approach, especially when it's coming to these long-term things like divorce and custody, because they might not, and honestly, they might not be there yet. They might not be ready to file for divorce. They might have religious reasons they don't want to file for divorce. So we have to come from a place of understanding of where they're at and a place understanding of what the courts sometimes do, and sometimes that's really not good or fun for a survivor to go through, and make sure that they're mentally prepared for the process. One thing that I hear a lot of is, well, I need to file first because I need to show that I care about my child. The court does not look at it that way. It is not, this person filed for custody, so this person's the loving parent. That's just not reality. Usually it doesn't matter really at all who files first. The abuser files first, the court doesn't hold it against the survivor. The survivor files first, it doesn't hold it against the abuser. Like, it's just however the door gets open. You just get this kind of attached name of petitioner versus respondent. Those don't have any actual meaning in the outcome of the case. Only time that could happen is if there's a question of where they should file. Sometimes that does play out, because if you file first where you want it, that might help you. And we'll talk a little bit more about that later. But most of the time, this rush to file is not actually used to someone's benefit or to someone's detriment. And that's really important to remember, because people don't think that. Like, really, people don't understand that it is fine to be the respondent in a divorce and custody case. Absolutely fine. The court's supposed to look at what's in the best interest of the child. This is the legal term that is used. And they look at a lot of different things to decide what's in the best interest of the child, whether or not, we agree with that's a whole nother issue. But who files is not at all a part of this decision from the court. So other things to consider. Filing costs money. To file for divorce and custody, it does. It costs money. Some people don't have money. Some people do have a little bit of money, but it's much better to use that money to invest in creating a more safe situation for themselves. So that's important, because it does cost money. Responding to a divorce and custody case does not cost money. So by taking on this onerous of filing for divorce and custody, right there, you are putting your money towards it, and you are giving the other person the ability to respond for free. So you have that ability to make the other person file, and then you get to respond for free. Filing takes effort, and we'll go through the paperwork and going to court and stuff like that. It's a lot easier to respond. Like the response is just a one page saying, I agree with this, I don't agree with this. And I mean, filing, like going through the petition, especially when someone's really overwhelmed, it takes effort. And let's be honest, when someone is recovering from leaving an abusive situation, sometimes they don't have the steam to do this. And we have to approach that from a place of understanding. If they just don't have the energy right now, they don't. So let the other person file first if they want to. And it's more work. Filing first, like I said, the petitions are much more detailed than a response. So there are a lot of things to take into consideration when you're talking about this. So when should someone file? Some people just want to be divorced. Like that's a real element. And you know, the thing that I see it the most on is not necessarily the wanting the divorce, it's they want their maiden name back. That's a huge thing. So if they want to file just because they want to get divorced, then let's help them file by all means. When there are money issues, property issues, things that need to be divided like that, and the parties are married. So if you have someone who's racking up a bunch of debt, going out and buying all kinds of stuff on credit cards, and we'll talk a little bit more, that's community property, community debt. And so that could potentially be used against your survivor, and they might be forced to pay for some of that depending on the situation. One of the things I'll see is the survivor wants to buy a house, but wants to be divorced before they buy a house because they don't want this other person to have any rights to that house. That's a very valid thought process. So things with money, things with property, things with debt, when they're married, a lot of times you should file for divorce and you should get it over with and get it done. When the other person is threatening the survivor using the child, that you're never going to see your kids again. If you don't do this, I'll just take the kids. And the survivor has real concerns that, you know, they are going to take the children, or they're going to take them across state lines or across, you know, to Mexico or to New Jersey or to the Czech Republic, wherever you think that the abuser is going to take those kids. Having a custody order does give you that sense of security, and it also draws that line. They no longer have this ability to say that and have there be any legal weight behind it, because you've already fought through the custody and the court has decided this, and so we have to follow this, so you have to follow it too. So that's another time that sometimes it's worthwhile to go ahead and file for custody. The last one is very, very important. If the survivor needs child support is a part of the custody determination, and that's real. You might be able to apply through Child Support Enforcement Division and not have to go through a full custody case. So that's something that, you know, you could potentially explore, is helping them file through them. But sometimes you need to file a full custody case to get the financial support. And that is something that we have to think through and understand and really ask, because some people, one, don't want to admit that they need the financial assistance, and two, they don't want anything from the abuser. But the important way to approach child support is, this is something you are entitled to, and this is something your child is entitled to. We all hear stories about people not paying child support. It's a pretty common story to hear about. But, you know, if this is something that would benefit this family, then it's worthwhile. Also hearing I've definitely had cases where people don't want child support because they legitimately think it puts them in harm's way, because the abuser has told them time and time again, if you ever go after me for child support, I'll kill you. And I have had a case where we did a full custody case. And at the end of the case, she said, I don't want child support. And I asked her why. And she said, because I'm scared that he will come after me if it's ordered. And we asked the judge to reserve on the issue of child support. And the judge was very understanding and said, okay, yeah, we won't order it right now. But if she needs it in the future, she can come forward and ask for it backdated, pretty much was what this was. This was a great outcome. I don't know if every judge would do it, but that's another thing. All of these things kind of go both directions. You really have to talk to this person in front of you to see what they need, what they want, what their situation is, and just talk through and be a sounding board in some ways, because a lot of people are not asking these kind of questions and listening to it, because usually as they're talking, they're going to be like, oh, I shouldn't do this right now, or yes, I need to do this right now, and they will help themselves make that decision. But I think it's a really important process that I don't think a lot of victims get, is this ability to really think through this: should I or should I not file for divorce or custody? Because they need to. It's a long-term commitment, it's a lot of energy, it's a lot of effort, and they have to follow the court's orders. No matter how strongly they disagree with them, they have to follow the court's orders. So I want to talk a little bit about something called the Uniform Child Custody Jurisdiction and Enforcement Act. This is a mouthful. This is a law that is very complex, and you guys do not need to know all of it, but you need to know that it exists, and you need to know when to kind of cue in of, this is a case that she needs to talk to, or he needs to talk to an attorney, because these things get very complicated. There are attorneys in 2 states by the end of it sometimes, and it can get a little bit crazy. So I just bring this up so you can kind of flag when these things are issues. Pretty much what it says is that when a child's been living in a state for 6 months, that state has the authority to make a custody decision. So they can make custody orders once that child has lived in the state for 6 months. Now, this really comes into play in domestic violence because survivors tend to flee the state, especially if their family's in a different state. A survivor fleeing domestic violence or child abuse may ask the court to take emergency jurisdiction to make a custody determination, and would be up to the court to decide if they have the ability to say it's an emergency because of abuse. So, in other words, if you have a client sitting in your office who just fled here from Texas, this is one of those wait, if they're thinking about filing for divorce and custody, we need to get them in touch with an attorney. I do want to flag, these people can absolutely still file for orders of protection. In New Mexico, for the most part, judges are pretty good at understanding that if you're filing for an order of protection, that's about abuse in and of itself, and therefore the emergency jurisdiction can attach through that. But they might want to talk to an attorney before they file for an order of protection in these situations, because they might need to be very specific about what happened, or they might need to be very specific about where the child was and what they're asking the court to do. So just to flag, these are cases that you can utilize that domestic violence helpline, or even potentially send referrals before the petition for order of protection is filed to New Mexico Legal Aid, because sometimes it is helpful to talk to someone beforehand. If your client wants to go to a different state, so if you're sitting there, domestic violence happened in, Valencia County, and Survivors like, my whole family lives in Oklahoma. I just want to go to Oklahoma. That's another one of like, let's have a referral sent. Let's call the DV helpline something, because filing for an order of protection, if someone wants to leave to a different state, sometimes can keep the survivor in New Mexico. One of the general provisions that's in an order of protection is that the survivor can't take kids out of the state. Blanca, you have a question? Go ahead.
Yes. Sorry, I just back to if someone comes from another state, because they're from another state, will New Mexico Legal Aid be able to help with that if they qualify?
Yes.
Okay.
So New Mexico Legal Aid does not necessarily require that they be like formalized residents of New Mexico, anything like that. If they're in New Mexico, or if they have a New Mexico action, the main thing is this question going to be determined in a New Mexico court? I'm licensed to practice in New Mexico courts. I'm not licensed in Oklahoma or Texas. So if they're coming from another state and they need help with a state issue that is in a court in another state, usually we can't help. If it's an issue that is in New Mexico, whether the survivor is here or in Oklahoma, if the issue is in New Mexico state court, that is something that we can help with. Also, just want to flag here, New Mexico Legal Aid, as I'm sure most of you guys know, you flag, okay, New Mexico Legal Aid helps low-income clients. Survivors of domestic abuse, we do not have income requirements, and we do not have citizenship requirements. So don't let that be a hindrance to send people to us to get help. But yes, very good question, because a lot of organizations are like, no, that person has to be a resident of the state. Ours is much more, what court are we talking about? Now, if we're talking about New Mexico courts, then that's something that you guys can send us. So yes, so going back to, if someone is wanting to leave, I would have someone talk to an attorney before they file anything. I will tell you, if they file for divorce and custody, they might be stuck here for a very long time, because it'll be up to the judge to decide whether or not they think that that person should leave. And it takes a lot to get a judge to think that. It's not, judges don't like people to leave. They think New Mexico can provide what's needed. So that's an important thing to think of. Terry?
Just wanted to give you a heads up. It's 10:29, almost to the mid mark.
Perfect. Thank you. I appreciate it. I tend to talk more than I plan to talk, and definitely need time markers. So yes, before a client files for an order of protection, even if they're wanting to leave to Colorado in like 3 days, pause, talk to someone, don't file anything, like kind of anything, because orders of protection usually have things saying that you cannot even leave the state with the children, let alone permanently leave the state with the children. Divorce and custody cases, same thing. They have what's called a temporary domestic order that says you can't move the children to another state. So pause, that's when it's time to get an attorney involved. So just remember, kind of 6 months in your head, if they haven't been here 6 months, or if they're wanting to leave right away and not going to be in the other state 6 months, that's when it's time to kind of bring in an attorney to talk to them. So just 6 months, write that down in your head. The rest of it, we can kind of figure out. Okay. You need to file for divorce if you're legally married. It's important to ask people if they are legally married, because some people call someone their husband when they are not actually legally married. Or sometimes they won't call them their husband and they are legally married. So asking that question really tells you which of these two things you need to do. And I know that sounds basic, but I've been like halfway through things and they're like, oh, but we're not actually legally married. And I'm like, oh, never mind, let's rewind. So just to flag that. So divorces divide property and debts. Community property, community debts, and then people who have separate debts or separate property from before they were married, the court like acknowledges that that is that person's property or debt. And then if they have children, a custody determination is a part of the divorce. If the couples aren't married, they need to file for custody or paternity. The court can determine paternity if dad didn't sign the birth certificate, if he didn't acknowledge, if he didn't do something saying this is my child, the court can make that determination. And the paperwork does kind of ask some questions about whether or not dad has acknowledged that this is his child or not. Court will sometimes help with property divisions. I want to put a big asterisk next to sometimes, not always. So if you're not legally married and you have property issues, a lot of times courts force you to go to either magistrate or metro court to work out who has what. And that's a pain in the ass. And I just flag that because people ask, and sometimes you can get some things through, but like big property divisions, sometimes not. It can get kind of messy with that, but it is not technically a part of a custody case. There is what's called an application for free process. I want to bring this up because, like I said, filing for divorce or custody is expensive. It costs $137 to file, and a lot of people don't have that. And if people can't afford it, they can file an application for free process, and the court looks at their finances and then says what they think that they can pay. The lowest the court usually grants is about $30. I've seen it occasionally where they don't require that, but it's rare. That $30 is pretty hard to waive. The applicants ask really detailed questions about their finances. It's invasive. They want to know how much you're paying for car insurance. They want to know how much you're paying for childcare. They want to know how much you're paying P&M. They want to know how much you pay for groceries. They want, a lot. Do the best you can in answering it. It's not, when you say, what's the monthly amount you pay for groceries? If you're like, I estimate $200 a month, that's fine. Some months you're going to pay 124, some months you're going to pay 300. It's not exact. So do the best you can is what I would say with that. If you're married, it asks for the other person's income and property and assets. A lot of domestic abuse situations, they don't even know the answer to that, let alone have access to how much that is. So there is a place that says, if you don't have access to it, explain why. Make sure that they fill that out. But no, if they don't know the answer to it, that's not really a checkbox. Just have them right next to it. I do not know. He refuses to give me any information. I don't know. I think she works, but I'm not sure anymore. Whatever information they have, just have them write it on the side, because what you don't know, you don't know. And some people feel weird about writing things on the side like that, but that's all you can do. So just go ahead and do that. A lot of courts require this document to be notarized, and that is a hindrance to people who do not have an ID. And I just want to flag that. So you can try to get it through without it being notarized, but some require it. A lot of courts have waived it due to COVID, because finding a notary in COVID was difficult, especially in the height of COVID. I don't know if that'll go away or not, but just know that might be a barrier for people you have, especially if they're not able to access an ID for whatever reason. It usually takes the court a little bit of time. In Albuquerque, it can take up to 2 weeks. So this is also something that where you need to file for divorce or custody or something right away. This is a roadblock, because it takes a while for these to be looked at. I would say some of the rural courts do it faster than the metro courts, but it's hit and miss. Each division's a little different. Okay, want to talk to you about 2 different sources to find actual paperwork, because getting access to that actual paperwork is really helpful. If they go to the court, most courts say that you can buy the packet of paperwork, but it costs money to buy that packet. Everything is available online. You will have to print it out for them though. So, but just know that. So the first one I want to talk about is something called New Mexico Guide and File. This is actually a website through the court. You have to create an account, and then it asks questions and it kind of spits the forms out for you. It's helpful. It's better than the forms. The questions are easier to understand than the forms, but it's still a little bit cumbersome. It's a little wonky. It's a little bit confusing. I really recommend that you guys go on and create your own account and make some divorce papers for random people, so you can learn what it's like. And that way you can, I mean, this would not be legal advice. This is helping them fill out a form. So sitting with someone on Guide and File and helping them fill out that form is something that you guys can do. So the site is Guide and File. It's actually up on the website right here. I went backwards. Hold on. Retreat. So it's this website right here. We'll send you out a copy of the PowerPoint, and this is a clickable website. You can also be really techie and Google NM Guide and File, and this is the first thing that comes up. But yeah, so looking at that is worthwhile. The annoying thing about this, because there's always an annoying thing, right, is that there are no custody or paternity forms on this. So this is just for your clients who are looking to file for divorce. I know, fun. I think that the goal is to eventually get the custody paperwork up. However, I don't know why it's not there. I think that this is something that they were working on a lot in 2019, and COVID happened, and I think that it's just kind of fallen a little bit. Thank you, Devanese. Devanese put the site in the chat as well. So yes, this is a good resource, but like I said, I would get on and I would play with it. Know that you can do that. It like asks about an interview. No one's calling you. You're not talking to anyone. You're literally putting information into a computer. So have some confidence and do it yourself. I know the first time I did it, I'm like, oh, well, is this going to like send something to the court? No, you have to print everything out. It doesn't do anything except help you create the forms. So you can go in there and kind of mess around and, you know, divorce Donald Duck if you want to and learn how to do it. There are a gazillion forms online. So there is the main statewide form database, and that website is here. And I'm going to show you where to find all of these here in just a second as well. But I want to point out that some districts have their own forms, because of course they do. And some districts have great forms. Some districts have crappy forms. So some different districts have forms that, you know, are really helpful, but aren't in other districts or aren't in the statewide forms. Some districts only have a few forms that are also in the state. Nothing is uniform, okay? And it's just looking around, and actually taking some time to look at some of those can be helpful to your clients, because if they want to file, you know, I don't even know, a request for hearing, there's a form online for that, and you can just learn and know that. I'm going to talk about a couple of general things to know, and then we'll go through and I'll show you some of those websites real quick. So you can give information. Remember that. Information, not legal advice. So once you start saying, well, based on this, what you should do is, that's when you should kind of cue in and be like, okay, no. You have to just give that information and that general, like, let's talk through it. If they need the legal advice, the advice on what to do in their legal case, that's when you kind of contact us and see what we can do. Couple of things to note: community property and debts. Community property is income and property that you obtain during the marriage. There are some exceptions to this because it's law, and there are exceptions everywhere, and we can't have anything like completely as a yes no answer. It will drive anyone insane. And so the thing to remember though is it doesn't matter whose name the property is in if it was purchased during the marriage. So in other words, that truck that is only in the wife's name, but they bought while they were married, husband, wife, equal access. Okay. It doesn't matter if only one person earns an income. If wife has an income, stay-at-home mom, they have the same access to that income, and it is community property, and it is just as much one person's as the others, even if it's technically one person who's earning that income. It gets confusing because people are like, well, this is my money. I earned it. They just stayed home. Technically, if you're married, it is community property. What you're earning, what you've purchased is both of yours as the community, and the court splits it in half. Same thing with debt. Credit card is just in one person's name. They're married. What they put on that credit card is both of those people's responsibilities. And the court with community property looks to divide this equally. So even if, let's say, husband goes out and buys, a lot of things at the local gas station and runs up a huge credit card debt, and wife doesn't even know about it, wife is still somewhat on the hook in this situation. It can be very helpful. It can be very harmful to people. But just know community property, things that come into the marriage or go out of the marriage while you're married, are equally divided for the most part. Exceptions can include student loans, gambling debt, money that is someone receives as an inheritance. There are a couple of other exceptions, but just to give you some ideas of what I mean by there are some exceptions. A couple of things to remember is retirement accounts. People often overlook that. One spouse works, the other one doesn't. One spouse has a retirement account. The spouse who doesn't work has access to that retirement account because that is still income that was created while they were married. So the income that the person put into the retirement account was community property because they're earning it while they're married. So the other person has rights to that retirement account. I said, gets complicated. So if people need advice on this, send them our way. But just some things for you guys to know about, because I do think it's helpful, because you can give some information on that. Spousal support, definitely get questions about that. One spouse might be entitled to the other one giving financial assistance after they're divorced. General rule, married at least 7 years, and there's some kind of imbalance of power. So, for example, wife, in a case that I had their first child when she was 15. Husband proceeded to get pretty good work, pretty good experience, got a pretty good job, was making quite a bit of money. Wife didn't graduate high school, stayed home, took care of children, did things for the benefit of the community. The court looked at it and said, no, she is at a disadvantage because of what she put into the marriage. And so you have to give financial support. So those are just some things to think about. But if someone's only been married for a couple of years, or they're both medical doctors and making lots of money, court probably isn't going to order any type of spousal support. Quick things about custody to know. There are 3 different buckets to think about. There's legal custody, there's physical custody, and there's child support. These are all things that are determined when they decide custody. Legal custody is that decision-making power. All of those things that kind of make you a parent because you're in charge of knowing these things, where the kid lives, where they go to school, religion, doctors, medical care, all of those kind of things. And the court in New Mexico has a very strong preference for joint legal custody. You can get past it, but the court's goal is both parents keep this legal custody. Physical custody, that's pretty apparent where the child is when they go see the other parent. Court likes for both parents to be a part of kids' lives, and that's something to overcome. when both parents actively say they want to be a part of kids' lives and one parent is abusive, it is a challenge because the court will give that person opportunities. They will try to come up with, therapeutic reunification plans. They'll do a lot for that parent, trying to keep that parent involved in the child's life. Last thing is child support. Child support is not based on how much it costs to have a child. That's a very important thing to know, because having a child is often much more expensive than what child support looks at. What child support is it looks at the income of both parents. It looks at costs of medical insurance for the child, daycare costs for the child if the parent works, and then extraordinary expenses. So let's say your child has a medical condition and needs certain types of medical devices that you have to buy a lot. That would be an extraordinary expense. The court takes that information, puts it in a calculation, and spits out how much you get in child support based on the number of kids you have, and then the amount of time each parent has each time of responsibility. There is a nice little website where you can put all this information in and it'll spit out a number. Things might need to be tweaked here and there depending on what is going on in the legal process, but I think it's really helpful for parents when they don't have any idea what they'd be entitled to for child support, to just put some information in and play around with what they could possibly get. And so that website is also here. Let's see. Okay, I still have 12 minutes. I'm mildly proud of myself right now. Real quick, there are a couple of things that people who are representing themselves, they're called pro se litigants, should know about. The first one is where they need to go to file paperwork, when they accept paperwork in the clerk's office. These are all things that you guys can learn about your local courthouse, because some courthouses are different and some courthouses change and some change a lot due to COVID. When someone is taking something to the courthouse to file, make sure they bring the original document and 2 copies, so a total of 3 of that document. Like making sure they know what a motion versus an order is. A motion is something that a party is requesting that the court do. An order is the court telling people, this is my decision, you must follow it. And they really must follow it. Courts really get mad when people don't follow orders. Make sure that they know that when they're asking something, so when they file a motion requesting something of the court, they have to file a request for hearing. And this is saying, hey court, you know that thing I asked for? I actually want to talk to you about wanting it. I don't understand, but that's the rules, smile and nod. And then they must provide a notice of hearing for the court to send out. So people must actually give the paperwork. The court will write in the date and time of the hearing, and then the court will mail it to the people. And that leads us to 2 stamped pre-addressed envelopes. So the court does not create its own envelopes. Ha ha ha. So you have that notice of hearing that the court writes in where it is, and then you have 2 pre-addressed envelopes that the person who files the motion brings. And the court puts those notice of hearings in those envelopes and mails them out. So those are important things that they need to bring to the court in these cases, and it'll save them a lot of hassle and a lot of heartache. Okay, I'm going to get out of my PowerPoint. I'm going to stop sharing my screen because I can work a little bit better when I know what I'm doing. Okay, and I just really quickly want to show you these websites. So, okay, so this is the district court's website. And if you look, there's a lot of different things on here. It's very busy. If you go to self-help and go down to forms, this will take you to the link that I included in the PowerPoint. Divorce and custody are in district courts. You click that file, and they're called domestic relations cases. You click that file. And then there's divorce forms, kinship guardianship forms, which we didn't talk about, and custody forms or paternity forms. So divorce in custody or divorce has a lot of things. And even if you're filing for custody, I would recommend people look in this divorce portion, because things like we were talking about notice of hearing and request for hearing, those documents are under divorce. So they have access to those documents if they go to that divorce portal. The custody cases, of course, I went back too far, I forget. It's the other thing, you can't use back buttons in this, you have to use their back button. Their back button's important. The custody forms suck. There aren't a lot of them, like at all. And they're not very great forms. So what I would recommend is, like I said, each court has their own forms. So if you go to NM courts up here, there's a bunch of, first, second, third, fourth. A lot of these courts have much better custody forms. So I would look at your local jurisdiction custody form, but I want to point out the metro areas custody form. So this is Albuquerque. Albuquerque is the second judicial. If you look over here on this side, there's a place that says forms. So you click that and you get totally different forms. Family court forms. And if you go to parentage custody packet, look how many more forms there are. So it's an adventure. If you guys ever need help navigating that, absolutely something we can do. But this form for establishing custody is a pretty good one to use. It gives the court all the information. There's a lot of stuff that people will need to fill out. If you have any questions about how to fill these out, or if people have questions about how to fill these out, let us know. That's something that we can potentially help with. So yeah, that is divorce and custody in a nutshell. What questions do people have?
Before we get to the questions, I just wanted to notify everybody that I'm going to go ahead and stop recording and also stop sharing on Facebook Live, so you all have privacy to ask your questions. So thank you all for joining us on Facebook. This will be available on YouTube for the information that Sarah Coffey shared with us today. All right, perfect.